Let me say this. Would you rather 12 people hear your case and weigh it, or would you rather there be one person that could make the decision and you have to pay that person handsomely for their time?
A group of my peers,
right?
Hands down.
Exactly. You get one person, and that person, if they have the slightest bias, you would never know.
Or just a bad day.
Is exactly
That's
right.
all it takes.
That's exactly right. Hello, everybody. Welcome to another edition of Lite, brought to you by Foreman, Watson, Holtree, FWH Legal, from the high-rise white tower at 530 Frederica Street. It is a beautiful spring day. We are glad to be here, back in the saddle. Haven't been here for a while. Peach, how you been, man?
Good. And it is a beautiful day.
It's a sin to be doing a podcast indoors on a day as pretty as this.
We should do a podcast outdoors.
We will. I think from a golf course would be a wonderful place.
I mean,
just
that sounds
to do,
like a blast.
I know you don't golf, but still, it's a good idea.
Hey, if it's nice like it is today, then I'll hang out on a golf course.
Okay, deal. Done. Let's schedule that. All right. So, it's been a while. I think the last time we sat down for podcasting, we had a guest with us. And
Nathan was here.
Got a lot of positive feedback from Nathan's comments and his involvement with the podcast.
Yep.
I did have an experience the other day, PJ, where I was on another podcast. Did I tell you about that?
No, but I saw you were cheating on us, but it's okay.
No, I was not cheating on us. I was getting experience to make us better. How's that?
Okay.
That's
You were
there's
with
always
Jordan,
a way to
correct?
spin it. Right, Jordan from 97.1.
Mm-hmm.
He asked me to be on his podcast, what's called Feasting with Friends.
Yeah.
And
The Viking.
The Viking. We go over to a restaurant here, Dee's Diner. And we have something to
Dee's
eat.
Diner.
Yeah, we eat, and while we're eating, we pod a little and cast. And so it was interesting. He just kind of asked me a bunch of questions about my career and why I chose the path I did and things like that. But it was a good experience. It didn't replace the fun that I have doing Lite. I mean, Lite's awesome. If you hadn't heard, people are talking about us everywhere.
Yeah, we were just talking about that before we started podcasting.
That's right. And we're going to keep podcasting.
Really, I would say we are Owensboro's premier podcasters.
I would think so. I've not met any other besides Jordan, but so far.
Yeah.
But
how long has he been doing his podcast?
I was his third episode.
Oh, okay. So he's still a baby.
Right. And, we need to have him on here to repay the favor. That would be a lot of fun.
That would be fun. So I like Jordan. He's a good guy.
So let's kind of look ahead at where we're headed. We are in the month of March. Hard to believe, right?
Yeah.
It's already March. We have set aside here at the firm March to be a month where we notify and inform the public about attacks on their rights and constitutional rights and access to the court system and access to jury trials. And it's something we believe very wholeheartedly in, bringing that to the public's attention, right?
Right.
And so our marketing for March is centered around this whole idea, the fact that our rights to a jury trial and some of our rights within the court system in the civil cases are being attacked every day. And people don't even realize it, okay? Right. A lot of things that are done are legislation to cap how much a person can get in a civil lawsuit. So what that is that's lawmakers saying, look, those are bad when you lose your leg in a car wreck, but you should be capped on the non-economic damages, trying to say your pain and suffering can only be worth so much. That's somebody telling us how much our pain and suffering is worth, as opposed to a jury of our peers hearing the evidence about how losing your leg will affect the rest of your life.
Right.
And them saying, hey, you should be compensated in addition to your lost wages, some non-economic damages for your pain. your suffering, your inconvenience, the misery that you've had to go through with this, whether it's surgeries, whatever. And so that's just one example, but there's multiple attacks at limiting people's access to the jury. A word that you've probably heard 1,000 times and never realized, that arbitration. Mm-hmm. The word arbitration is basically saying we are going to submit your case to a decision maker that's not the jury. It's one person that's not a judge. It's an arbitrator, and that person. And so when you buy a car or you finance a house or you sign your kid up for some league, and there's this fine print in the sign-up papers that says, I'm agreeing that if there is any contest coming out of this or any disagreement as to the terms, that I'll submit it to mandatory arbitration. Well, guess what? That's being upheld, and then people realize, well, I didn't know I signed that. I didn't know that was in there. You can't go to court. You can't go get a jury to hear this case because you're now submitting it to mandatory arbitration. There are countless examples of these things happening. The organizations that I belong to are fighting against that. We're going to Frankfurt. We're going to Washington, D.C. We're trying to keep a lot of those measures from taking place or being put into law or advancing, so that we're protecting people. And one of the things, and this is where you and we've talked about this, I don't think people know this, number one, which is why we podcast, is to educate the public. But number two is I don't think that people appreciate the fact that attorneys like the ones we have here are giving up of our own time and giving up of our financial resources to fight that battle for people that we don't even represent. Okay? Yeah. Now, somebody may look at that and say, well, the reason you're fighting that battle is that it'll totally cut you out of the equation. No, the reason I fight that battle is because people that are injured as a result of someone else's wrong are entitled to compensation for what they lose. Right. And taking that away from a jury process and capping it and saying that they're only entitled to a little bit, or capping attorney's fees for the work that we do for these people, I believe it's unconstitutional, and I believe it's wrong. And so that's why we do it.
If I can interject real quick,
sure.
I'm sure there's someone listening to this right now thinking, okay, big deal. There should be a cap because it's ridiculous that someone gets $280,000 just because they spilled hot coffee on themselves. Yeah. And the funny thing is I kind of used to be that person, in the sense where I would say, oh, somebody got 1.5 mil because they spilled hot coffee on themselves. That must be nice. It wasn't until I started working here that I started realizing that, at face value, it seems like, oh, they just spilled hot coffee on themselves. What you don't realize is that these people are getting severely burned and getting nerve damage that's going to last them for the rest of their lives, and it means continued treatments, continued doctor bills, hospital bills, and we all know how ridiculously priced most of that is.
Right.
And therapies, and that's for the rest of their lives. So if they live another 60 years, they're going to need that money because it's expensive. So, I don't think people take that into account. I know I didn't.
I'm glad you went to say, and for people that don't know, we do not script these conversations. We just sit down with microphones in front of us and go at it, right?
I'm not that good of an actor.
Right. Well, there is actually a documentary called Hot Coffee, and it tells the truth behind the hot coffee case.
Yeah.
And there is a lot that the public never knew, okay? And the reason that hot coffee was done was because in about 90% of the jury trials that happen in this country, civil jury trials, not criminal, but civil jury trials, attorneys will tell you that during the selection process of the jury, the hot coffee case comes up because people say, I think it's a shame that people are getting so much money for such frivolous injuries. Right. And they mention the McDonald's hot coffee case.
Yeah.
And so what happened was a documentary has been done telling the truth behind that case. That case was interesting because not only did the person suffer burns, but she suffered burns to female parts of her body, and they were grotesque. And McDonald's had been warned that exact thing would happen. and did not take the steps to reduce it because it would cost them some money. And when you add all of that together, you can see why a jury or that heard that thought, you know what, this is ridiculous, And so, and one of the other things that people don't realize, and I'm glad you mentioned hot, because that's exactly what most people think. Well, we hear about coffee.
Yeah.
The system's already built with safeguards. We have a rule in our trial rules, in our civil rules, Rule 11, that says if an attorney does something that's wrong, files a case that shouldn't be filed, puts his name on a pleading, he can be sanctioned. We already have mechanisms for getting rid of cases out of the court system that have no merit.
Now, is that done by the judge?
It's done by the judge.
The judge says this is frivolous and ridiculous, so we won't go forward with it? This doesn't meet the standard of proof, the burden of proof. You have no way to give me facts that would allow this to go to the jury. I'm cutting it off. It's called a motion for summary judgment. All right, I didn't know that.
And so, anyway, the system that's set up polices itself. If people say, well, we've got way too many frivolous lawsuits, it's interesting. We have verdict reporters here in Kentucky looking back for 22 years, okay? In 22 years ago, in 1998, there were, I believe, and I'm within a few numbers here, but there was car wreck cases in Kentucky. In that year alone, in 1998, there was 263 jury trials, okay?
Oh, wow.
In the year 2019, guess how many?
I'm going to say it doubled or tripled, maybe?
And that's the problem. There was 33. 33 trials in 2019 involving... Now, if we have so many frivolous lawsuits, people are going crazy filing these lawsuits that have no merit. Why do we only have 33 jury verdicts?
Exactly.
Right? And the point I'm making is that there are no statistics that can uphold the fact that more and more frivolous lawsuits are being filed. There are none. But yet it gets thrown around, and then so people, when they come into the jury, they're already tainted because they hear it through mainstream media, And so again, one of the reasons that I'm a member of these organizations that I'm a member of is to educate myself on these topics, and then to educate the public and to go fight for the public even when they don't know it needs to be fought for.
Right. Now, when you were saying like in 1998 there was that many cases, now do you think that there was a certain percentage of those that were considered frivolous, and then over time they kind of saw the difference between the cases that were and the ones that weren't, and they just weeded all those out, so now we're down to 33.
Here's what I think. I think that's 263 or 268 jury trials, okay, in car wreck cases. Now, there were jury trials in slip and fall cases. There were jury trials in medical malpractice cases. There were products liability cases. But no, I think if it went all the way to a jury trial, that it wasn't frivolous, because the court would have had the ability to end it a long time before that. Now, and the end-all be-all is that 12 jurors of our peers, hear the facts, and they can award a zero.
Yeah.
They can award a zero. They can say, you haven't proven to us that someone did something wrong, or, yeah, somebody did something wrong, but you haven't proven to us that your injuries are real or that your medicals were necessary. And so they can give you a zero even at that point, okay? So, and that's the point. Our founding fathers that wrote the Constitution of the United States understood the importance of a jury trial. They understood that it had to be a part of the system. It had to be where a person had the ability to come in and civilly put on a case, let 12 people or 9 people or 6 people, just depending on what venue you're in, hear that, weigh it, and rule.
Yeah.
And while it has its flaws, okay, there is no system better. And that is very important for our listeners to understand. And so that's why we do all we can to protect people that aren't even our clients yet from this attack. And it is real. It's very real. And not only are the attorneys here doing it with their time and involvement in these organizations, we're doing it with our money. We are donating a lot of money, of our own money, to help protect that precious right to a jury trial. And so, I've been a lawyer for 24 years, and I've been in and out of the courtroom, and
Right.
I can tell you, I remember one time, PJ, you'll like this. I was leaving the courthouse down here, brand new. I hadn't been practicing law a year and a half, and one of the older attorneys, I think I may have mentioned this to you, one of the older attorneys was coming out of he was coming out of the courthouse, and I was going into the courthouse. And he said, "Hey, what you doing?" And I said, "Well, I'm getting ready to go in here and find justice for my client." He said, "Well, then you're going the wrong direction. It's like you're not going to find it in there, And so that sometimes there's some apathy among lawyers that we get, when we don't get it our way, that it must not be justice. But I've never forgotten him. Well, you're going the wrong way, So, but in my 24 years, I've seen a lot of amazing things happen in the courtroom. I've seen a lot of amazing things happen with juries and things like that. And I believe in the system, and I always have great memories of that, and look forward to making many more. But I believe in the system.
Yeah, I actually was a part of a jury trial that lasted about 4 days. It was the police against an individual who he was a drug dealer, basically, is what it came down to. And it started with the very small drugs. Once they got through one drug, they would say, "Okay, now we're gonna start discussing this next narcotic that was far worse." And he was like, and it turned out he was selling it to children, and he was selling it near a school, and they brought in all this stuff I'd never seen before, and techniques that drug dealers were using to like hide paraphernalia and secretly storing and stuff like that. And it's interesting because when I first went in there, I did everything I could to try to get out of being I was like anybody. I was like, I got better things to do than this. It was one of the most interesting processes I'd been a part of. It ended up being something that when it was over with, I was personally glad to have had that experience, because you do kind of feel like at that point you're a part of justice. You're helping make things better.
Exactly.
And when things deal with kids, I have no, what's the word I'm looking
tolerance?
for? No, exactly. Yeah, I have no tolerance. I have no sympathy for people who do things that harm children.
Right.
And at that point, I was ready to throw the book at the guy. And then, of course, when you go back to deliberate, the deliberation lasted probably 3 or 4 hours. And they brought in all the box of paraphernalia, and we got to look at everything in photographs, and it was, I love the movie 12 Angry Men, and it was just like that movie in a lot of ways, because you had some people who were ready just to get it over with and just move on. You had other people that were that were like me in the beginning, that were like, let's just throw the book at this guy. And then you had other people like myself who was like, no, we need to sit and we need to really talk about what's happening here. Let's start with the very first aspect of this case, which is it's a human being that we're discussing. Now let's talk about what this human being did. And we actually ended up throwing the book at him at the end, and we ended up making the paper because our verdict was like one of the most harshest drug verdicts in, I think it was like 50 years or something like that. But it was a process that, like you said, it's not a perfect process, because you have a bunch of strangers. Some people don't care and they're ready just to go home. But I think when it's over with, you have enough people in there who do care, and you get through the process and it's done the way it should be done.
Let me say this: would you rather 12 people hear your case and weigh it, or would you rather there be one person that could be that could make the decision, and you have to pay that person handsomely for their time?
A group of my peers,
right?
Hands down,
exactly. You get one person, and that person, if they have the slightest bias, you would never know,
or just a bad day.
That's exactly
that's
right.
all it takes.
That's exactly right, and that's what's so dangerous about arbitration, And so, anyway, it's going to be a great month. One of the things that we've decided we wanted to do, I think, was share a few of the funny stories about trying cases or having cases, and I've thought of a couple that, because you had asked me to think of, hey, what are some, since we're going to be talking about access to jury trials and courtrooms and things like that, and I've been kind of holding these in some of our other discussions that came up. I kind of wanted to talk about them, but I knew that the time would come when it would be more on subject, on point, and so one of the funniest stories that happened, and I before telling this, I have not gotten this person's permission to tell the story as far as using his name, and so I'm going to leave it very vague, but the point will come across.
John Smith.
Yeah, that's right. So the attorney that I worked for at the time was a very good lawyer, very serious about the work that he did, was a great trial lawyer. And in the middle of trying a case, he had asked a friend of his to read a deposition into the record, okay? Now, all that means is this. Let me back up. If I take the deposition of Dr. Seuss, okay, and then I have that deposition. It's in digital format, question and answer format, or it's in a little booklet, question and answer.
Right.
And it's recorded what that person said under oath, months ago. Okay. Well, rather than calling that doctor out of his busy practice or out of her busy surgical practice to come over to court in Davis County and waste 3 or 4 hours testifying, there are rules that allow us to take that deposition and use it at trial as opposed to the doctor coming. Now, we can videotape that, but sometimes for reasons, the attorneys make the choice, no, we're not going to videotape it, but what we're going to do is we're going to read it into the record. And when you read it into the record, the attorney can pick any person they want to read it from the witness stand. And you want to get somebody that can pronounce some of the words and that'll make a good impression. And so this attorney had used a friend of his the time came and he was going to call the doctor by deposition. And so he had asked his friend to familiarize himself with the transcript and to take the witness stand. So, and that's what they do. This person who's not a doctor takes the deposition transcript, sits in the witness chair, takes the oath just like it's read in the deposition, and you begin to question the doctor, reading back and forth from the transcript. Please state your name. My name is Dr. Seuss. And doctor, where do you practice medicine? I practice in Louisville, Kentucky. And they're just reading it right out of the transcript that was taken 6 months ago. Okay, just as if they were there.
Right.
Well, this guy the attorney I worked for at the time had asked to be on the witness stand to read the deposition, was a little nervous, okay? And so he was kind of rocking in his chair. And I'm in my chair right now. He was rocking back and forth while he was reading. And I could see that, my supervising attorney was getting frustrated with the fact because it was a distraction that everybody in the courtroom saw him, and his rocking got bigger and bigger and bigger. And about the time was like, I could tell that, that Charlie was just boiling, okay? And the guy that was reading this is tilting in his chair, and the chair flips up and crashes, and all you hear is this guy cussing and like, blah, and papers shuffling and stuff like that, and the jury is dying laughing. And there was only one person in the courtroom that was not laughing. The judge was even laughing. The only person not laughing in the courtroom was the attorney I worked for, and he had this death stare, like, I am going to kill you. I am going to kill you for flipping out of your chair. And so, and if I would have, it would make it even a little better, because there's some things I could tell if I would have gotten that person's permission, because I know the guy, still see the guy that was in the chair, but I hesitate to use his name because he's well known, and I'd hate to use his name without his permission.
This podcast is so popular, he'll forever be known as Chair Flipper.
Yeah,
and when people
flipper,
see him in public,
they'll say, you're the Chair Flipper. So
yeah,
only
it'll be like a
scar. Would be the jury,
It'll be a scarlet letter for him.
Well, anyway, that's a great story. One of them that I will tell people about is like, and the people that know him would just even die laughing more because it just fits his character. But anyway, it's a great story. One of the other ones, and I actually shared a little bit of this with Jordan on the last podcast. He asked me the funniest thing that had ever happened in courtroom, and this has got to be one of the funniest things that happened and with me, okay? in Davis County, we have a juvenile courtroom.
Okay.
All right. Now, it's not used as that anymore, but at the time it was juvenile court. And the reason it was called juvenile court, and there's a specific purpose, was any matters involving juveniles are confidential for safety purposes.
Right.
And so they built this real small courtroom because the idea behind it was, if it's a matter involving a minor, we don't need room for the public and for all these bystanders to be standing in and listening or sitting. And so we're going to make it just the bare necessity, small little courtroom, okay?
All right.
And I was handling a case in juvenile court, and as were 5 or 6 other lawyers, we were all there waiting our turn. The judge, and I don't mind to use his name because I've told this story 1,000 times and he knows. His name is Judge Goble, and he was a district court judge for the first 3 years I practiced law, and then he went up to federal court and was a magistrate judge. Okay, and Judge Goble was a very good judge, very detailed, but he was also what I would say on the stricter side of running his court. He was no nonsense. Okay,
all right,
and so Judge Goble was conducting court one day, and let me set the stage for you.
Okay,
setting the stage, that's your lingo. Let's
right.
set the courtroom. The judge would have a bailiff, a sheriff, stand at the back door. Okay,
all right,
and the purpose of that judge was to only allow people in if it was their case being called, okay? Because, again, for purposes of confidentiality with minors, they didn't want just people coming and going. So they stood a bailiff right there, and they would say, the judge, when he would finish one matter, he would lean over to his clerk and say, okay, what's next? And the clerk would tell the judge, hey, it's the Tom Smith case, and so then the bailiff's job was to open the door out to where the public was waiting and say, if you're here on the Tom Smith, or you call the case, please come in. And they would come in. He'd make sure they sat, make sure they took their hat off, whatever, Well, that day there was a brand new bailiff, and he couldn't have been on the force very long. I mean, he was younger than me. I mean, he was young, and I was a young lawyer. Okay, this guy is standing by the door, and he had a bad habit. What he was doing to do his job well was he was putting one foot like outside the door and one foot in the courtroom, and let the door kind of lean on his shoulder, and then that way he could hear what the judge was saying in the courtroom, and then he could also kind of keep an eye on what was going on out here.
Yeah.
And so Judge Goble says, all right. He points at the guy, and he said, I want that door shut. And the guy goes, oh, okay, and he doesn't shut the door, but after saying, oh, okay, he opens the door further, which we're all like, what is he doing, And he sticks his head outside, and he says, Doris, shut. Doris, shut. If you're here on the Doris shut case, and all of us in the courtroom, I mean, we were doing our best, and not until just totally lose it. And the judge turned as red as that folder on he turned 15 shades of red, and he looked like he was about ready to explode. And I can't remember exactly the words he said, but to a certain extent, it was, you moron. I asked that the door be shut. I was not asking for Doris shut. And then when the bailiff heard that, he was embarrassed, and he turns totally red.
Right.
And the courtroom was just totally out of order for a couple minutes. I have never said, when I see Judge Goble, I always say, you remember the Doris shut case? You remember the Doris shut case? So, a good friend of mine who practices law here in Owensboro was in court that day, Mark Pfeiffer. And we will never forget. That's one I've written down as one of the stories that I'm going to tell or put into a book.
That's pretty good.
Stories. So
that's like right out of the movie Airplane or something.
Yeah, right. Exactly. Now you you have in any of your film stuff, have you ever thought about using the courtroom setting or anything like that? Because there's so much that can be drawn into that and play off of that. In any of your filmmaking, has that been a thought go through your mind to use that as a setting or a storyline or anything?
I mean, I'm always looking for new places. Now I've shot in courtrooms before. When I used to work for the TV station, we did some live election night coverage.
Oh, okay.
From it's the second floor, the
Right,
courtroom that's
right.
right when you go up the stairs to the left.
Yes.
As far as like shooting something for a movie, I haven't done that yet. But I mean, if it fits within what we're trying to do, I'd love to do something like that. But I mean, I'm a big fan of like courtroom drama movies. I watch those all the time. Like Runaway Jury is one of my favorite.
Right.
So I would love to do something like that. Of course, it'd have blood and guts in, I'm sure. But
Yes, that would make it for you. And of course, unfortunately, one of the things is back in those days, there was no courtroom really. There was no metal detectors to go through. I mean, people would just come and go in the courthouse. You didn't have to go through metal detectors. You didn't have to do any of that before you made it into the courthouse. Now, because of a series of shootings and bomb threats and things like that across the country over the last 20, 30 years, we have you can't get into a courthouse now, judicial centers without going through metal detectors. So definitely. If you're going to do the blood and guts thing, it would take special clearance.
They would know ahead of time. I don't. I used to I would ask for forgiveness rather than permission. It used to be the case, but now I do it the right way.
Right.
And
well, good.
We have insurance and all that stuff now, so things are done.
The thing about TV court drama and things like that, and TV shows, L.A. Law and The Practice and things like that, is that these cases that they go, they at the beginning of the episode they're in their infancy, and by the end of the episode they're doing closing arguments. And a lot of one of the things I've learned is that my clients, they think that cases should move like they do on TV, and they really don't. I mean, they take years and years sometimes to mature and to go through all of the phases that they need to get it ready for presentation at a jury trial. But other than that, I find that some of them are interesting. I find myself when I'm watching TV, I'm like, well, I'd object, and Missy, it's like, just be quiet. You're not, it's not, it's TV, and I'm like, well, that's objectionable. I mean, and it's like, so it's hard for me sometimes to watch it,
right,
and not, critique the legal work, just much like I'm sure doctors look at.
Yeah, I have friends that I work with who work with the police and the sheriff's department, and I usually, when I'm doing something that involves police or the sheriffs, I'll consult them and say, here's the scene. If this was you, what would you do in this particular situation? Because I want it to be as realistic as possible. Because I've talked to them before where they're like, every time I watch a movie, I'm thinking that we don't hold our guns like that. That's not the right protocol. You can't just do this because
right.
they come down on
all
you.
That. I mean, people have this idea about police. People have this idea about lawyers. People have this idea about doctors. So, but I mean, but there also is a place for those things, and some of them can be funny, and some of them can. And I like the ones that document actual stories from courtroom. They have actual courtroom testimony televised as a part of a documentary and things like that, because it really adds to it to see clips from the jury trial or those kinds of things, especially on some of the criminal shows. I think that's great TV. I really do. Well, listen, we got a lot of great things. We've been kicking around some ideas about having some kids on the show, and some things today the idea of doing something outside pops up. So
I think that would be cool.
With the weather finally cooperating, hopefully it looks like we have some things that we can do to spruce up and spice up, so we were not always saying that we are sitting at the high-rise
White Tower.
Right. We will be somewhere we'll have to exaggerate being in the middle of the redwood forest or something,
Right. We
something
could do
like that. And we have to
Today we're at the top of Mount Rushmore.
That's right, and people wouldn't know.
No.
You know, they just wouldn't.
We should do a road trip series where every episode we say, "Hey, we're in Las Vegas today," and I'll just
Why you just gave it away? Just gave it away because nobody's going to believe us when we say it now.
Well, the people who haven't listened to this episode, they won't know.
But everybody's listening to our episodes.
That's true.
PJ.
That's true. I totally ruined it.
You forget that all the time, like when you gave away the Santa Claus thing. You know, I just couldn't believe it.
I plead the fifth.
Yeah. Anything else to cover today?
No, I think we're good.
All right. Well, onward and upwards,
Yes.
as Brian Jackson says down at the radio station. This has been another episode of Law Lite, brought to you by Foreman Watson Holtry, FWHlegal.com, and we are signing off.